Thank you so much, Jarvis, for joining us. Jarvis Archer is here from Revive Financial. He's our favourite insolvency expert. And I'd like to ask you, start off by asking, what do you do?
Cool. So, I'm a liquidator in terms of my formal registration, I guess, the top one that I've got. And generally, I guess it's a bit of a double-edged sword, isn't it? Because usually liquidators are seen as the person that the corporate undertaker should be avoided at all costs. But I think it's probably a bit more of a traditional view. And I mean, you've got a range of people in any industry, but I think there's a more progressive approach largely being taken by liquidators to support businesses more, to work through their situations rather than just offer them, closure and fear and doom and gloom. So I think more of what we do now, or at least in my approach, is more of a corporate doctor approach, providing information and advice about ways for businesses to stay alive, what happens if you don't, and just really, I think it feels for people like it's like an unknown or a cliff if you start talking about the I word, insolvency. And so really I see that showing people actually, no, this is what it is, and potentially it's not as bad as you think, can really help restore some confidence and help them make reasonable decisions. So, I mean, key things I guess we talk to people about are what is the state of their company. Often, every director wants to trade through as well and thinks, no, we'll be right, just need this next job, or, next month it's going to be good. But really just pressure testing the reasonableness of their assumptions and sort of going, well, sure, you've got a 400 grand debt, but you're only making 30 grand a year profit. Will you really be able to pay off that ATO debt from just trading through? And talk about the options for their business so they can see, actually, it's not all just a crash in the heap sort of option if they're asking for help. So that's what I talk to people about. I guess I spend most of my days rather talking to people about their situation and what the best ways are out of that situation.
Sounds like a really interesting job, and is not as dark and gloomy as we potentially would think on the outset. And that you're actually really providing some really good advice, modern advice there. Thank you for that, Jared. So what does it mean for a business to go through the liquidation process?
Yeah,
Share
cool.
it with us like we're five.
So I think, we're going to talk a little bit about what liquidation.
Okay.
Yeah. I guess to give a bit of context before getting into the details. So,
thank you.
Look, I thought I would just expand just on the insolvency terminology generally, because if I talk about liquidation, people might not connect it with what they think liquidation is. So I guess receivership's a word people hear a lot. That's just where the bank appoints someone like us to a company to recover the bank's money. Now, basically, since the against the 60 Minutes show about 5 years ago, where there was a receiver out on someone's farm and ANZ looked terrible and receivers looked terrible, the banks had a real PR focus, and they've really wound down their receiverships, and they're working with clients to try and help them sort out their situations now. So the next option after receivership, there's administration, and that's really for businesses looking to keep trading. That's what you read about. The big retail brands, Virgin is in administration, and that's really a process. Generally, it's quick, 5 weeks, but it can be longer for bigger companies, and that allows them some breathing space to consider, can they restructure their debt? Can they stabilize their business with the current owners? Or do they actually need to just find a buyer for it? And that's what's happened with Virgin. They've traded it on to the extent that they can to find someone out there that can come in, has enough money to recapitalize it and take it into the future. So if they don't sell it, something called a deed of company arrangement is basically a deal with the company's creditors to say, hey, can't pay you everything. If we go into liquidation, you might get nothing or a couple of cents in the dollar. But here in the middle, we want to do a deal where we pay you 20 to 50 cents in the dollar over a year, 2 years, or it could be a big lump sum if they go and get new finance. Do that deal to say, hey, it's in everyone's interest to keep going. if you take a bit of a haircut, we'll do what we can to pay you more than you'd get in the worst case scenario. So that's administration and deed of company arrangement. And then liquidation is really, for a company that's insolvent, administration can be quite expensive. And so a lot of small businesses, I think 98% of businesses are less than 2 million turnover. They might not be able to afford the fees for an administration, which can be 40 to 100 grand for, you know, a month or two of work. So that's where liquidation is really the option for them, to hand over control to someone like me that knows the lay of the land, can do it legally, wrap it up, deal with the creditors, so the director's not there getting hounded by people chasing money. I sell the assets if there are any. I investigate what happened with the company's affairs. I do a report to ASIC, and I tell creditors. So it really takes the responsibility off the directors, so that hopefully they can move on and do something new. And if they do want to keep their business going, then they can always buy the assets back from the liquidator or the business. So there is always an option there to kind of keep going. Now, outside of those 3 formal insolvency appointments that you often see, there's really, I'll just talk about that, I guess, the informal space, we call it, where I'm not appointed in a formal capacity, but I might be engaged to advise people. And they're really a turnaround where it's just turning around the profitability, managing cash flow, might be involving finance and ATO debt negotiation. There's safe harbour protection. And it's been around for a couple of years now, and it's what the government has mandated over the last 3 months and up until about the 25th of September to say, hey, directors are protected from insolvent trading or personal liability for their company's debts if their company's insolvent. So at the moment, until 25 September, directors incurring debts that their company can't pay, they're technically not going to be liable, but after 25 September, it returns to normal, and directors do become personally liable for company debts if it does turn out their company is insolvent, which means it can't pay its debts as and when they fall due. It's pretty basic, because there's a lot of companies sort of in that situation. And so what Safe Harbour does is says, okay, well, actually, if you tick these boxes, you're paying your employees, you're lodging your ATO returns, and you can satisfy a test that it's called a better outcome test, that trading on will be better than closing down today, then you can be protected from insolvent trading liability. Now, applies to bigger companies where they've got hundreds of $1 million of turnover, and a director doesn't want to make his personal assets potentially be available for his massive company's liabilities, but it can be relevant for small to medium enterprise as well. And then the last thing, and the turnaround safe harbour, is restructuring. And look, that can refer to restructuring a company's capital structure, getting new finance or an investor, and rescheduling its debt to give it a strong base. But it also commonly refers to, I guess, in the industry as a related party sale of business. So that can be a director with a company that's insolvent selling the business and assets out to another company that he's also the director of. Now, it's very attractive, and it's grown in popularity in the last 5 to 10 years because there's minimal disruption to the business. The director controls the timing and the process, and they just get a valuation, hopefully, and sell it. But the serious risk there is if they do it incorrectly, not for fair value or not on commercial terms, and possibly with their accountant's advice or someone else, then that could potentially be an illegal Phoenix transaction. And that's, we've probably read an article or two here or there where ASIC are really heavy on that, and even I'm nervous about where I see those things, that I want to report everything I can to the to ASIC. So good option outside of an insolvency appointment. The company would then go into liquidation, though, after selling its business and assets, and that's where a liquidator would look at what's happened to the company's affairs and whether the director's done the right thing and whether any advisors have been involved. So I guess, it's a long answer to what is liquidation, but I think giving the full context is probably more help to people than just talking about what liquidation is. Look, no one comes to me and says, I want to do a liquidation. It's like going to the doctor and going, I want to talk about death. You want to talk about the alternatives. You want to talk about, surviving. So.
Yeah, okay, thank you for that really good explanation and the analogy with the doctors. Now, during that, we did have some questions come in, which I think are relevant, and for simplicity's sake, I will ask the questions.
Yeah, sure.
When you say administration gives them time to breathe, what are the benefits of doing that rather than just negotiating it on the quiet?
Yeah, that's a good point. So for businesses in the last 3 months, I haven't been telling anyone to a point, because if they're on JobKeeper, if they do have some viable future, well, you don't want to restructure your entity and fix your current problems, and then lo and behold, you're back into the trouble. And, before you need to sort of bottom out before you're on the way up. So the best thing you can do is negotiate everything. But if you do have a difficult say landlord or other supplier that wants to push or wants to be difficult, or if you've just got too many creditors that you can't actually manage them all, then administration is a collective process. It binds everyone. It prevents secured creditors from recovering their assets, and then it puts the administrator in control of the company and control of its cash flow. And so there's a moratorium where creditors can't take action against the company, and they can't take action under personal guarantees against the director personally for that 5-week period.
Thank you for that, Jarvis. Now we have another question. What about pre-existing debt prior to safe harbour provisions being announced?
Yeah, well, if the company does go into liquidation, which is where insolvent trading becomes, I guess, comes to life potentially, then directors can be personally liable for it. Now, I will say I've done, I think, 130 liquidations in the last sort of 2 years. Fair few. They've all had insolvent trading, and I haven't sued anyone for it. I might have settled some of them, but usually directors probably don't have anything. That's the main reason. It's not commercially worthwhile suing them. And it may be that they've got other defences available to them where they've been providing financial support, or it might be that the amount of the claim isn't really that significant. Because, look, it is actually, as common as it is, a liquidator, just like if you think about entering into any legal action yourself, you have to evidence it and put it all together and instruct lawyers. And so the cost can be 100, 200, 300 grand to go to court. And that's just for the lawyer. That's, so there are hurdles there. It's best just to do the right thing. And if you're conscious of it, just be proactive with advice. So.
Thank you for that, Jarvis. What does it mean? And I'm not sure whether you've answered this or there's some more to add to this. What does it mean for a business to go through the liquidation process?
Yeah, cool. So, look, I'll talk just about liquidation so that we don't try to cover everything. But look, liquidation, it's really just about wrapping things up. Director moves on, and the liquidator really gives creditors the answers they need and a sort of end of the line in terms of recovering their debt. So what I do, I get appointed, I take control of the company's records and its affairs and its assets. I notify creditors of my appointment and say, hey, don't call the director, call me. I've got all the answers that you need. And then I look at, okay, what happened before I was appointed to identify whether there's any legal recovery claims. So did the company have assets that it doesn't have now, which have been inappropriately dealt with, and I could recover those to get money in to pay back to the creditors. And then I lodge a report with ASIC on any conduct breaches of directors. So usually they're minor and usually they don't lead to much, but on occasion you have people that do the wrong thing. And then after I do all that, I apply to ASIC for deregistration. So look, we run a pretty efficient process. Liquidations can go on for years. We look to wrap them up within 3 to 6 months, because generally these days there's not a lot of money in companies. They're either financed or there's just a small amount, sort of $5,500 that we get before our appointment. If that's all we're going to get, that goes pretty quickly. So we don't want to do heaps and heaps of unpaid work. So we look to wrap it up in sort of, well, really 2 to 5 months for most sort of small liquidations. And then it's only longer where there's ongoing investigations or asset realizations.
Thank you for that, Jarvis. We have a lot of accountants and bookkeepers sitting in on the session here. What is the relationship between the accountant and the bookkeeper and you, the liquidator?
Yeah, well, hopefully good one. So it's generally short. It's Liquidator. I don't know the company usually. Maybe the couple of discussions. Maybe I've been introduced by the accountant, but we get a lot of online leads. So we're going to the accountant. It might be the first they hear about it when we get in touch and say, "Hey, we're the Liquidator." So I appreciate, no one wants to do unpaid work, and particularly if the accountant or bookkeeper has unpaid fees already. They're already a bit angry at the client. They feel a bit angry at the Liquidator. But the Corporations Act says, look, you have to give the Liquidator the company's books and records. Now, that doesn't include work papers. So just usually zero access, a few years of financials, maybe some tax returns if they're around, but I get all them from the ATO anyway. So it can be that easy. It can be just a simple email with, this is what we did for the company, here's last year's financials and the year before, and zero access if the director hasn't already given it to us. And that's it. That's all you're really required to do. And look, people wonder whether they should go and do all this work to get the company's records up to date. But look, we usually don't spend the money on doing that because there's not a lot of benefit to all the other creditors. It really just lets the ATO know what their debt is. And really what I'm interested in when I look at financials is where value is, where there's assets or money that can be recovered. I'm not worried about it all lining up and balancing out because a lot of that value depletes, goodwill, etc., depletes when you're looking at liquidation. It's more about realizable value. So so look, just short and sweet, get it over with, and that's pretty much all you'll hear from the Liquidator. But it's an opportunity to talk to someone if you don't already have a relationship to find out how relationship can benefit you, because for a lot of firms, I act as like an extension of their firm. They just call me up when they've got a client issue and they're not sure about, just like you would with any other particular specialist areas around a company's business, like legal or insurance or things like that. So happy to take those calls.
Yeah. I'm really astonished that you said that the client calls you before they call the accountant, and the accountant can be potentially surprised that has happened.
Yeah. Well, I guess, look, a lot of the time, I think where your bill goes unpaid as the accountant, I think, as professionals, we always struggle to ask people for money. We don't like asking for money. We just expect people to sort of pay us. And so what happens is the relationship can deteriorate. Either the director can be unhappy at the accountant and they blame the accountant for their financial difficulty, and then the accountant says, well, you need to pay my bill. And look, where a client says, I can't pay your bill, what they're actually saying is, I'm prioritizing everyone else ahead of you. And so you need to know, hey, you're actually in some serious trouble. Paying everyone and continuing like normal isn't going to fix your business. Working harder is just going to get you down into a hole faster. You need to come and see me. We need to get your book sorted out, work out what your options are, call contact the Liquidator, and let's have a chat and work out what your future looks like. So that's really the important thing. I mean, what happens often, I think, is that the accountant will say, oh, well, you're not paying me, I don't want to talk to you. But in my view, that's when the client most needs you, even though, the relationship can be a bit troubled. If you can save them, then you'll have a client for life, and you'll retain a client rather than losing one. So I know it's tricky. I think the key is just get paid up front. But I mean, we do a lot of our work comes from online, and so it is interesting. I think increasingly people come online. I guess they're a bit embarrassed. The relationship's not that good for whatever reason. But you're right. I think accountants and bookkeepers, we can all do better to build that relationship. So I mean, I expect everyone watching this probably has very good relationships, and their clients would turn to them. But there's a lot of accountants out there that don't have that sort of proactive relationship with their clients, and all they're doing is perhaps getting another ATO payment arrangement, but they're not addressing the bigger issues for the client.
Yeah, absolutely. Thank you for that. And Brooke Holmes from Practice Ignition just joined us, so I'm sure she's cheering about the getting the payments up front comment that you made.
Yeah.
It's July 2020, and we're in the midst of COVID-19 and lockdown. And many of us have supported our clients through tax stimulus efforts. But we know that there are still issues out there. What questions should the accountants and the bookkeepers be asking their clients now to support them?
So I think I'd hope that most accountants and bookkeepers would know the financials of their clients probably better than their clients actually do. So look, the key points, I guess, for me are, so what you're asking them, look, I think ask them, big picture, what are you doing to stabilize your cash flow and monitor that, and then maintain the profitability of your business. And this is where, everyone watching can add real immense value to their client, because, you've got the same structure, the same things that need to be dealt with in every business client. So beyond just cash flow management, it can involve and reporting. It can involve obtaining finance or looking for an investor, cost cutting, pivoting the business to improve turnover, closing parts of the business that aren't making as much profit, or selling assets, or selling some or all of the business to really try and maximize the value there. So it is uncertain, but I think if we put our heads together, then at least we can come up with the best ideas in the circumstances. So I think probably a key one is understanding what those clients on JobKeeper are going to do after JobKeeper ends in September. Hard to know what the government's going to do. On one hand, I think Scott Morrison last week said, oh, well, some businesses are just going to have to fail. I think I saw another article that said there's about 1,800 businesses that ordinarily would have gone into liquidation over this time, but because of government stimulus and measures, they're just floating around, probably just getting JobKeeper, and so maybe they just will close. So for those that are going to survive, what are they doing? And they really need to prepare for that now. You can't get to September, have JobKeeper end, have no cash to pay wages, and then hope to survive then. So I think it's really all the business all the accountants and the business professionals need to be proactive with that discussion with their clients, as hard as it is.
Yeah, absolutely.
Probably a key one that I think always gets missed is just asking and making sure they're paying their super by the due dates, and if they're not, get those SGC quarterly forms in by the due date, because if they don't, they become personally liable for the super. And I think it's always been a hidden debt super, at least before STP. And so people just sort of, accountants assume that the client's paying the super, the client isn't paying the super and doesn't really know what to do if they can't pay it. So they just sort of wait in the hope that one day they do pay it. So don't let super become a hidden, a hidden debt. I think you're probably going to know if their ATO lodgements are up to date and happening. And then I think probably a key one, which I'm sure is close to your heart, but ask how they're going personally, because it's obviously, it's very stressful, and a lot of business owners, they never think that they would be in this position. I mean, usually they don't anyway, but a lot of people have been caught out, and it's really isolating for them. They can't really talk to their family about it. They don't want to talk to other people they deal with about it. And so I think that's where those of us that they can turn to, and it's confidential, and we know what their numbers are, then we're probably the best people for them to talk to about that.
Absolutely. Deborah Anderson has posted that they're expecting 30% of SMEs to close down at the end of September, which is very startling.
Or during COVID, because
of course we had a cat appearance. What are the signs, and you may have answered this, but I'm just going to touch on it if there's anything else you want to add to it, Jarvis. What are the signs that a business should start considering liquidation and should start talking to their bookkeeper, accountant, or to you?
Sure. So look, I think, probably rather than liquidation, probably just talk about insolvency. And so insolvency definition in the Corps Act is very simple. It's if you can't pay your debts as and when they fall due, then you're insolvent. So ATO, often the last to get paid, and super last to get paid. Now, technically, if you renegotiate that into a payment arrangement and you meet the payment arrangement on an ongoing basis, well, you are meeting your debts as and when they fall due. If you fail a payment arrangement, then you're not. And so that's a sign of insolvency for us. So where we come in and see 3 or 4 payment arrangements that have been defaulted, probably could have sort of had a discussion sooner. So look, I think liquidators generally say, look, it's never too early to get insolvency advice. Worst case, you've got peace of mind. I guess best case, you've got peace of mind. Worst case, you've got a plan for what your options are ahead, and so you know what there is there. You've got some structure about thinking about your business. So insolvency generally evolves slowly. It's sort of a hands off the wheel approach, as I usually see, unless there's probably one of 4 key incidents, which, I mean, obviously COVID, but a bad debt or a loss of a client, loss of key staff, director illness or dispute, or a divorce, often where, one partner does the books, and then all of a sudden it becomes a big schmozzle and the director just loses control. So so if you see any of those major incidents, certainly at those points you need to have a greater control. And then if things are deteriorating and no real improvements are being made, then that's the time to sort of have a discussion about, well, how do we change the trend? But look, key things probably, again, super. If it's not getting paid, then that's a problem. ATO debts just keep going, and payment defaults. Bad debts and director loans get left on the balance sheet and just prop up the balance sheet with no prospect of repayment. I mean, I've got a ledger of 500 grand last week, and I thought, great, there's going to be lots of money. 160 grand of that is owed by a company already in liquidation. 180 is disputed in full. So all of a sudden, the 500 grand ledger is being reduced to hopefully maybe 40 to 50 grand actual recoverable money. So those debts shouldn't be on the balance sheet. I think we all agree with that. So having a realistic balance sheet, and particularly where director loans are, ballooning out and there's no prospect of them being repaid. And then where you said creditor payment terms, accounts payable extending out to sort of 30, 60, 90 days. And probably a key one is if they're not paying your bill, I mean, surely there's no reason why they wouldn't unless they couldn't. So that's a key one that, hey, we need to have a serious chat about what you're doing here.
Yeah, yes, thank you for that, Jarvis. Now, Ryan wants you to write a book. He's loving this session, so he wants you to pop out and write a book on this. Electra Frost asked prior to the session, which I'll pull in here, she's concerned about her departing clients who are looking insolvent. Should we cover ourselves, herself being an accountant, on the way out?
Yeah, I guess it ties in a little bit with what I said before about if you've got a client in trouble, that it's an opportunity to help them. Look, there's only so much we can do with clients. I mean, a lot of people I speak to say, and probably everyone watching has had a client come on and go, oh, the last accountant, they did all this wrong and it's all their fault. And you think, well, who's actually running the company? I mean, were you doing anything? So, so I think the key is there. Okay, look, you try to help. Now, if you can't, sure, they're going to finger point. There haven't been many cases that I've seen where accountants have been held responsible for something that's happened in the business. I mean, we're advisors. There's a line there. Unless you're going and making decisions in the business, which I suspect most of us aren't. If you were, then you're in that shadow director sort of status. But you're pretty safe. But look, I think what my thinking is look, if you can see that the client they're heading down, they're not going the right direction, and they need some professional help, either you provide that help or you say, hey, look, I can't help you to the extent that you need, but here's someone that can, and refer them to have that discussion, and then put it in writing and say, look, I think that you need to seek insolvency advice. Here's the name of someone that can do it. And look, I think a lot of accountants and bookkeepers are worried about having that discussion because they're afraid of losing the client. But at the same time, if you don't have the discussion, you're probably going to lose the client anyway because...
Yeah, I'm thinking about ones that are on the way out anyway.
Yeah, they're going to, they're probably not going to pay your bills, so then you're going to be extra angry because
they don't want to pay us going forward. They haven't appreciated the JobKeeper stuff we've done, and they're not listening to me when I say they should get insolvency advice. I'm just wondering if I should document it, or if it's even an ethical objection type of issue at all.
Look, I guess, I don't know. I mean, your engagement letter probably, look, people have some expectation, and I guess that's why they come online and find me. But I think it comes down to the relationship, really. Having difficult discussions. Your relationship's either going to weather them or it's not. As a professional, you don't want to facilitate this company, just getting another payment arrangement, another payment arrangement. Lo and behold, the tax debt just grows from 30 to 50 to 300 grand, and they've got super debt, and you sort of think, well, I sort of kept the ATO from taking the action against them to stop that sooner. Was that the right thing to do? I guess form your own opinion, but I think, look, best thing you can do is tell them that's what they need, put it in writing. If they want you to continue doing work, that's fine, but require payment up front, because you don't want to do work for someone that's not taking your advice anyway, and they're not going to pay you. I'm sure you've got plenty of other clients that would appreciate the advice, even if you did it unpaid for them, and would otherwise appreciate your advice enough to pay you for your time.
Yeah. Thanks, Jarvis. Yeah, no, I'm just going through the annual proposals for this year at the moment, and I'm getting a lot of rejections from people who are insolvent. So
well, I guess
on that path. So they're saying, oh, sorry, we can't afford to continue with you, and we're going to another accountant now. So I'm just thinking, well, in my friendly, I hope things go well, good luck reply, by the way, here's Jarvis's number.
Well, a lot of referrals are from the new accountant.
The new one, rather than the departing.
Yeah, well, that's right, because they come in and, you're going to say, oh, well, actually, like it's $7 or $8 grand to clean your books up. Oh, you've got a year worth of outstanding lodgements. If we go and lodge that, we know we're going to have a big tax debt. It's in zero anyway. It's just the ATO is going to know about it as well. And they're not going to say, oh, thanks for letting us know. They're going to say, okay, well, you've done that, but you need to pay your debt now. So all of a sudden, it's going to really bring things to a head. So I think, look, you can't force the client to do things, but just engaging with them. And then going back to how I sort of started is, look, there's all these other options to save a business. And, often people talk to me and, often they get a bit of confidence, go, oh, it doesn't seem so bad, and then don't come back. But I think the thing is, I see worse circumstances come about because of inaction rather than action, right? So the conversation with me is free, it's confidential. Stuff that you didn't know before. You'll have some clarity. I guess, those sort of people, they don't want to know that actually, the business is a bit cooked and they have to do something differently. They have to accept reality. But the thing is, if you do that, if you accept that, hey, there's problems here and you deal with them, then you get better outcomes rather than, ignoring them and hope that they get better. So, hope is not a strategy. So, it's
hope is not a strategy.
Hope is not a strategy, which for a lot of business owners it is. So so there's a lot that can be done.
Thank you very much for that, Jarvis. Hopefully that answered your question there, Electra. The tax stimulus as well, supposedly they are ending in September, but I believe there's speculation all over the place. But what do you think here in Australia with the tax stimulus ending in Australia? What are your thoughts on that?
So look, obviously hard to predict anything with certainty at the moment. You want a government to give you certainty in business, and I don't know that we're having much of that at the moment, but it is a tough job as well. So I think what we do know is that various industries, tourism, hospitality, construction, travel, there's no, they're going to be affected. There's just, that's something that we know, and no matter how much stimulus comes forward, it's not going to be enough to save all those businesses. Hopefully it's enough to save the good ones, because we will need those industries going forward. So look, various industries, they're going to really struggle, and I guess they need to make a call. Hey, can I get through this, or do I just have to accept it and call it a day, and hopefully keep your house if you have one, and keep your reputation, and live to fight another day, as opposed to lose it all. The government stimulus, Scott Morrison said a couple of weeks ago, look, some businesses are going to have to fail. There's a lot of companies, the people that I was speaking to in March who had 800 grand tax debt, 300 grand tax debt, the ATO said, oh, we're not going to do anything till the end of the year. So they've gone, Cool. Free, get out of jail free. I'll see you later. I'm not talking to you anymore, Jarvis. So maybe come back in September. So those guys, they're going to have to, there's going to be a reality check, and the ATO will recommence their action. And the ATO can now, the credit reporting laws are now in. So if you've got a debt that's 90 days, I think over 10 grand, and you're not engaging with the ATO, then that's going to turn up as a default. And lo and behold, everyone's going to know that you've got debts. So that's a problem. Creditors are going to be able to recover their debts freely from around 25 September. And I met with a debt collector a few weeks ago. They said they've got to, that's their business, recovering debts. There's lawyers and debt collectors that they get paid to recover debts, and they haven't been able to for 6 months. So they've got a stack of statutory demands and bankruptcy notices that they're ready to serve at the beginning. And so that I don't see that the government is going to interfere with that mechanism of private industry, debt recovery, because it's hurting all those businesses that need to be paid their debts. And then I think, if you do have a business that it's 50-50, they're the hardest ones, the ones that you're not sure which way they're going to go and you just have to keep monitoring. Then, if it doesn't work out, then from about 25 September, the government relaxation of the government safe harbour is going to end, and directors are going to start becoming personally liable for those debts if their company's insolvent, and then it later goes into liquidation. So if they've got assets, if they've got things to lose, then they need to look at now implementing the 2017 safe harbour, we call it, to protect them from personal liability for their company's debts in the event that it doesn't work out. So, I guess I'll get a mention on that note. Look, the 4 key things that directors need to consider personally, because often the discussion will go very quickly from, well, what happens to the company to, well, what happens to me? And so, look, as a liquidator, if I'm looking at being the appointee to a company, I can give general advice to the director, but which is generally enough anyway for them to form a view of whether they're going to keep their house or be in trouble. But the 4 things: director loan accounts, always a troubled area. I think switching them to salary is good in a way, because at least the director loan account's not ballooning. And it's an awkward conversation when me and the accountant are sitting there with the director, and I'm saying, oh, yeah, see that director loan, you have to pay that back. And the director's going, well, no, that's my salary. That the accountant told me that's how we do it. And I'm going, well, yeah, but I'm going to have to demand repayment. So director loans, director penalty notices for PAYG, superannuation, and GST from 1 April. Big concern. You can't negotiate with the ATO. It's all or nothing. You can negotiate with a liquidator. So, be mindful of keeping your lodgements up to date and for super and your BAS, and then consider insolvency advice to an insolvency appointment to avoid risk, avoid becoming personally liable for your company's debts. Insolvent trading we talked about, and then personal guarantees. Look, unfortunately, particularly with leases, there's not a lot you can do to get out of them unless you can negotiate a settlement. But that's where, look, if a business owner, they just don't have the money to keep their business going, but someone else might be willing to walk in and take over the premises and take over the business and keep trading and take over the lease, most importantly, then that could be a good outcome. You might not be selling the business for what you think it's worth, but it's better to have someone in there running that business, taking over the lease, paying the lease, and you can at least walk away without 2 or 3 years worth of lease liability sitting squarely on your shoulders as the director. So, people think their business is worth this, it's worth this in liquidation. So I try to get them to recalibrate their expectation to be, hey, an outcome here, it's not what I wanted, but it's not as bad as the worst case scenario.
Absolutely. Thank you so much for that, Jarvis. Now, if you're ready for this, I'm going to open up to the Brady Bunch Zoom view, and we'll open up to questions from the group. If you need to grab a glass of water, Jarvis, because you've just spoken for 44 minutes solidly. So, look there, we've managed the Brady Bunch view. And Deborah, you're there. You've been asking a lot of questions. Oh, Deborah's grabbing water. She's been asking so many questions. Do you want to ask some of your questions, Deborah? And if anyone else...
I had a couple of questions. Do you only work with corporate structures, or do you also help sole traders?
Look, I do. I've done both. In the last 2 years, I've just been doing companies. But look, I'm happy to talk to sole traders. I mean, the beauty for them is that they can still be a sole trader through a bankruptcy.
Yeah.
They just need to put their name in the business name. Otherwise, they have to tell every single customer person they deal with in their business that they're bankrupt. So you just have it, John Jones trading as, Mike's Tackle, and that's that. So the key just is where they go bankrupt. There's an event there where you have to work out whether there's asset value that the bankruptcy trustee could sell. But look, a lot of sole traders, the businesses aren't. It's them really. So.
Yep. The other one I wanted to know was and I've actually got this situation, right, where I've sat down with a client and I've said to them, look, I really can't see a way out of this. And they just are so bloody positive that they can trade out of it. And I love them to death and I wish I had their positivity, but, it's 3 years now and yes, you've increased your margins, but you actually haven't made any progress on any of the other stuff. What do we do with those people? Like they're absolutely adamant they can trade through. How do I have that conversation, or what would you recommend I say to those lovely people that you'll probably end up speaking to at some point?
Yeah, well, you could tell them you've got a friend that's a business turnaround specialist, business debt specialist, business structuring advisor, something that's not what it is. I have partner on my email now, not liquidator, so maybe that's less scary.
That would actually be really good, to be honest, because I think telling them that they need to speak to a liquidator to understand their options is, as I said, they're just so positive, right?
Yeah.
And, I think, they've had business coaches and that kind of stuff. So I just really want to help. But
no, it's really dangerous. I mean, to turn around your business, you need two things, I reckon. One, you need to have the heart and the energy to get through the tough time and come out the other side. And two, you need to be able to accept responsibility and listen to advice. If you can't do that, you won't make the changes and you'll just keep doing what you're doing and sink eventually, because you won't be able to help anymore if it's ATO payment arrangements or expanding supplier payment timeframes or declining revenue, whatever their problem is. There'll be a point where someone will force them to act if they don't act themselves, and often that's the tax office, but it could be anyone else.
I think I've probably got a different view on the tax office to many people, but I think they've been too soft.
100%, yeah. And the ATO came out, Chris Jordan, a couple of years ago and said, we're going to cut down the level of debt before we start acting. We're going to be enforced more. And I don't think they have. I mean, I got appointed on something last week. I got appointed on something last week. The debt was 1.2 million or 1.8 million when I spoke to the accountant 18 months ago. They went off and it's been doing whatever and it's sold its business to a related company. The debt's now 3.2 million. Now, the ATO hasn't contacted them. So I don't know. I mean, I think that'd be on someone's radar. There's another guy who's got a business in Sydney, 800 grand tax debt, no contact. So, I mean, I understand, now they perhaps softly, but there's a lot of businesses that have big debts.
Yeah, I think has actually done more damage than it's done good. There might be the occasional time the ATO, and I won't say they don't, people have had a bad experience. But the fact is, I think we're just allowing them to rip off the Australian public, because that's what's happening, right? Like people who are just racking up debts, they're taking it off us.
Yeah, and I mean, I guess like the ATO says about, illegal phoenixing, like people that are paying their tax, they have to work harder and they have to remit their GST. So someone undercutting them, all it does is damages the industry as a whole. And I think because, we got kind of conditioned to see it from the client's point of view that, the ATO has been harsh on you, but you sort of think, well, I don't know, I pay my tax, you pay yours, so why shouldn't the client do the same thing as we do? We got to pay it. It's a lot of people say, I've got a great business if I didn't have to pay the tax, and I sort of like, well, it's not a great business then, is it? It's so you could say that about any debt. So I think the ATO should be more aggressive. I mean, I guess it's a political tool, really, isn't it?
It's not the word aggressive, but assertive.
Yeah, more proactive. If the debt's not being paid and arrangements are being defaulted, then that business is causing loss. It's probably causing loss elsewhere. I mean, obviously, super is the big one.
Yeah.
And that's not the ATO's money. That's the poor employee. So, and we've seen various instances where there's been underpayments of wages and then super as well. So,
Jarvis, just one more. Sorry, Heather. Just one more question. So in the case where we are helping the client to try and turn the business around, my big concern is our bill, right? So even if we get them to pay us up front and they mortgage their first child or do whatever they have to do to pay us to help, can that money be clawed back? And that's, we're actually putting ourselves at financial risk.
That's right. So look, a liquidator can recover payments made to creditors within the 6 months before liquidation. The hurdle there is that, well, a couple of, the hurdle is there you have to prove that the creditor that received payment had knowledge of insolvency. So if you're the accountant, that's probably not going to be a hard one to prove. And that the client was insolvent at that time. And again, we have the benefit of hindsight. So it did go into liquidation. So clearly it was insolvent at some point. But the defense is available to you as a creditor is you have something called a running balance account. So what it means is if you do work and you get paid and you do work and you get paid, well, technically the preference to you is just really the difference between the beginning balance and then at liquidation. So if you're owed $2,000 at the beginning and you're owed $2,000 at the end, well, you probably didn't receive much of a preference. But also if you're not a creditor, so if you get paid and then do the work, well, you're not a creditor of the company. That's the general rule with that one. So smart people do that and they get paid and then do the work. I mean, I certainly do. So that's just what you got to do. Yeah. So, and even if it's hard, like it's hard asking for the money, but you have to let them know, look, if they say, oh, I can't pay you, you say, well, look, you're paying all these other people. It's not that you can't pay me, it's just that you want to pay them before me, but really I'm more important to your business than they all are. So, let's see, what are your priorities here? Is it surviving or is it just making it through a few days until it all collapses in a heap?
Thank you.
Thank you, Jarvis. Carla, you've posted some questions. Do you want to ask them?
Yeah, sure. I'm just thinking about methodically including some of these things in our process. And I was just wondering if you have sort of any resources that you can share for us as bookkeepers and accountants that can, I guess, assist us with incorporating their conversations or trigger points or topics that might come up with our clients, and then sort of like a nice workflow of steps as to what point do we then jump on the phone, what are the reasons that we should, like just something that is really succinct and straightforward that can give us the triggers to go, okay, I need to call Jarvis.
Yeah, that's a good point. Look, I guess in terms of something that I could turn around and email to you right after this, no, I think we do have some step-by-step process, but I think it's about engaging us. That said, I'm happy to do something up. I think there was someone in the accountants Facebook group who asked about having the conversation, and I think Sarah Stein, and I did up a template email for her and gave that to her so that it just sets it out in that kind of more positive approach that I bring to it, as opposed to we've got to have an awkward conversation.
Because I think for I know the way that I would approach it is that actually making our clients aware of this before they even get to that point. So it's not being reactive, and we're being a bit more proactive, going, hey, Do you know this stuff? So that if we don't see it, if that, or if it's not picked up, or we have it implemented in our processes so that we do, but before it even gets to that they're aware of what does all this mean and what their obligations are and why we might have that conversation with them if we need to.
Yeah, well, I guess unlike you, I like writing blogs. I've been doing it for a while.
Did you read that?
Yeah, so
not my thing.
Yeah, unlike
well, you can do mine for me then.
It does take a bit of time, but you have to find your voice. But clearly, I've got a lot to say. But I write articles about the question, so I'm happy to, if you've got specific things, like there's an article, 10 personal liability risks for directors, and really I haven't seen anyone else out there write it. I think another firm sort of copied it a few months ago, but it's a little bit confronting, but at the same time, it's a bit of a checklist to go, okay, if this thing goes into insolvency, if your company goes down, ideally, that's it. There's no blowback on the director personally. That's why you use the company. But let's have a look and consider what that personal blowback might be. And so, again, the key four are around the director penalty notice, PGs, director loans, but that helps you kind of manage it before talking to me. And it also helps you go, well, okay, if we do an insolvency appointment and you are going to lose your house, well, maybe it's better to go and refinance your house now to support this business and potentially restructure in a way that the director becomes a secured creditor over the business's assets. So actually, if the business does go down, all the money comes back to the director first. There's lots of things there that you can do. Happy to have a chat about what they might be or outline something that I'm happy for you to use.
The stuff that I'm thinking is just, bringing it to the forefront of our clients' minds, having those discussions, making them aware of it, like educating people is the best approach. Then, we're not going to hopefully get in as many of those circumstances. But
that's what you want. You want them to be structured in a way that it can collapse. Like, I got hit by COVID, businesses collapsed overnight, but that's okay. My house is safe. I'm walking away without a lot of liability. Great. That's why I use a company. And unfortunately, it's that the benefit of that company structure is increasingly being eroded by short-term finance like the Mullers and the Prospers, where it's just personally guaranteed. The director doesn't talk to you. He just applies online. 50 grand turns up 3 weeks later. 50 grand's gone, but he's still got a debt there, which he's personally liable for. It's, and all of a sudden they might as well be a sole trader if they're not going to use the protection that a company offers.
Thanks.
So happy to chat about it. I'm sure you'll be able to contact me. So, yeah.
Thank you, Jarvis and Carla, for that question. Does anyone else want to take the mic and ask some questions? I know a lot have actually been coming through.
Jarvis, what sort of condition do you find people, just out of curiosity, what people's books are in? Are they generally in a mess and that's where they are now, or they just not that busy? Like, they might be an entrepreneurial person, but they're just not financially savvy? What sort of mess are their books in?
Look, I'd say it's a mixed bag. I'd say generally they're okay, but unreconciled for a few weeks or months, and that doesn't worry me too much. But there's a few that they're pretty up to date and they are proactive, and they've seen that, look, company's in a bit of trouble. They don't want it to worsen and owe everyone money and turns into big schmozzle. Their book's probably okay. Their accountant's probably got in touch with me, and it's up to date enough. And then there's people who, they don't have any books, or the Xero subscription was cancelled 12 months ago, and they've just been cruising along without any numbers. So it's a range, but I mean it's a thing that people don't see the value in the books as much as I guess we do, and I guess that's where we can add benefit by showing them the key numbers to look at and what the good news is, rather than just looking at the bank account and making a decision about whether it's a good day or bad day just based on the bank balance.
In a situation where you're approached by a liquidator and they say they want access to the Xero files, our online accounting software files, you did mention that we had a legal obligation to give them that access. don't I, one, need to confirm that with my client before I give anyone whom I have no idea who they are access? And two, for me to activate Xero files that are dormant is going to cost me money. Do I get to charge them for that money that it's going to cost me?
Okay. So let me rephrase. If you have the subscription, you can invite them in if the director hasn't already, or you can just go transfer subscription to you, Liquidator, you take over responsibility. You don't have to you don't have to be out of pocket for the Liquidator's benefit, and Xero will give a Liquidator 1 month free access to download all the reports. Anyway, so if you don't give it to a Liquidator, they can just go to Xero and ask for it. It is it's a bit more difficult than it needs to be, but if it's deactivated, you tell the Liquidator, hey, it's deactivated, you can go off and reactivate it at your own expense. So it's really whatever's the easiest for you to transfer it across. But certainly if you keep paying the subscription, then certainly ask them to reimburse you for that payment. But otherwise, just transfer the subscription and tell them, you've cancelled it, or you're going to cancel it if they don't take it over in the next 7 days.
Yeah. So I deactivated subscriptions. You're saying I can tell them to just go and approach Xero directly
100%, yeah.
about that. But if they pay me, I can open it up. It just costs me money if I actually go and open it up. I don't want to do that.
Yeah, the act, it's not intended to say, hey, you have to incur liability to support the company. So Xero have a form and like an insolvency notification form that we just fill out and send it off. So you don't have to be out of pocket. And if you're worried about being out of pocket, well, you tell the Liquidator you're transferring the subscription, or it's deactivated, or whatever. I mean, you don't have to go and do things that you're not being paid for, besides just hand over the records that you do have.
That's excellent. Thank you so much. That's a big learning for me. Does anyone else have any more questions?
Heather, can I just pitch in off the side of your question now? When liquidators do ask bookkeepers, quite often we get letters, asking us for these REMA reports. So it's quite all right for us to go back to them and say, look, it's an online file.
Yeah, you don't have to do that, or you can say, well, two options. You do it, or actually, it's going to cost me $500. Give me the 500. I'm happy to get it for you. So if a liquidator's got money, happy, that probably is happy to pay that. I'd be happy to pay that because the books better than me. But at the same time, if I wouldn't expect you to give it to me, and I can't make it, you give it to me. If all you have to do is give me the records, so. For virtual stuff, that's really giving me access to the records if I don't already have it, and if the director hasn't given it to me. So,
Jarvis, on that note, again, one of Heather's questions was about giving you the information and having to get permission. So I know this person who's on the TPB, and one of the things on the TPB Code of Conduct is that you're not allowed to disclose information to a third party without consent. So, and it's code item number.
Yeah, well, the liquidator should always provide you, if they're appointed voluntarily, they might provide the resolution, or they'll provide their ASIC form 505, which is lodged with ASIC, telling ASIC I'm a liquidator. And there's also a website called ASIC Insolvency Notices where every appointment is advertised. So that's a public notification. So the liquidator could give you a link to that ad and you can see, okay, it's public. He's said he's the liquidator. They could give you the ASIC form 505.
Therefore, as soon as you're the liquidator, or as soon as the liquidator is appointed, that client, that entity is no longer engaged by us. Is that correct?
I effectively become the director of the company. So okay. I am the company when I'm appointed. So
right.
No, I hear what you're saying. I mean, clearly, so if it's a court appointment, there'll be a court order saying, yep, Jarvis appointed liquidator. Clearly, the director in that case is probably not going to go and say, yeah, that's fine, Deborah, give him the records. He'll say, no, stuff him, not helping. And so clearly, it's a bit of an adversarial engagement sometimes. So
there is a piece of paper we can get. That,
100%.
Right.
Yep. No, look, it's all ASIC regulated. It's public. It'll be, show against the company's lodgements. So there should be no question in your mind. And if there is, we'll just ask for, more evidence from the liquidator.
And if we do that, I mean, we hand over the paperwork to you or hand over the zero subscription. But if we're, for example, the ASIC appointed agent, what do we do in that case? How do we?
It's a good point. Look, ASIC will keep sending out that sort of annual return fee thing. You just forward on to the liquidator. There's nothing else to do.
Advise though that we're no longer acting agent, because you need to.
It's look. I've never seen it. Some liquidators will transfer the registered office to their office. I never have. ASIC knows we're appointed. We're registered with them. They don't do anything after the appointment. They're not going to do anything to you. They will send out the sort of annual paperwork. Flick it on if you want, but that's as far as it goes. There's no trouble or responsibility for you.
Thank you for that, Jarvis. Any other questions? I don't want to keep on Jarvis for too much longer because he's shared so much information with us.
I think Michelle just said here, what about the company directors who choose to use the company bank account as their personal account, reasoning the company owes them money anyway? Well, if there's a loan account, it's an asset of the company. I'll be asking them to repay it. If they've got something, they might have to repay it. Otherwise, there'd be a bit of an accounting,
I guess really, like, I'm kind of going from the angle that Carla is I'm trying to avoid things. And so, for instance, I might have a company that has plenty of assets, plenty of money, very liquid, but they just use the company bank accounts for their own, for just ridiculous purchases. And I need to have ammunition to be able to say, look, this isn't the way to trade. So I guess that's what I'm looking for.
No, that's right. I mean, I guess some people set up that sort of profit first structure where you have a few bank accounts. You could put them on a sort of, even if it's drawings, on a sort of salary style payment.
They're on wages. So it's not that they don't have the money, but.
No. Look, it's a common problem that directors see that the company owes them. It's theirs, and regardless of its profitability, they should just be able to draw whatever they can out of it. And look, it is problematic. I mean, like I said, I don't know, there'll be an article around about the types of claims directors can face from liquidators it's a breach of directors' duties really if they're not acting in good faith and in the interests of the company. So it's not a problem as long as shareholders and creditors are getting paid. It is a problem otherwise. So. Yeah, I appreciate it. It is kind of hard to enforce when there's not a real pressure on them to do so.
Yes, thank you.
Thank you so much, Jarvis. Now, any last questions, or I'll wrap it up with Jarvis?
Is it worth becoming a liquidator? Do you make lots of money?
I was thinking the same thing. I was thinking, why would you do it?
That's fun.
No, that's right. Look, some do. It's. I think in the 80s, 90s, 2000s, there's probably good times, and the old liquidator driving the Maserati or whatever. But partnership
is living the dream in Noosa.
Yeah, look, there is a price on that. Being the only liquidator job in Noosa, that you can't really put a price on. But it's increasingly. I mean, like for all of us, like the regulation's increasing. The whole thing about illegal Phoenix activity, there's a lot of pressure on us as liquidators because we're registered by ASIC, while other people out there, unregistered advisors, directors, are just going about doing all these dodgy things. But the pressure's on us to report it and do everything we can. So I think since ASIC introduced that, was it user pays levy 2 years ago, the number's gone from 750 liquidators down to about 640. I don't know, like there's a lot of liquidators sitting around not very busy at the moment. And I think they'd be worrying about how to get through the next 3 to 6 months. And then when all the work does hit, how they're going to do the work, because you don't want to staff yourself now, but then pay people for 3 to 6 months to not have much to do. So look, I think a lot of liquidators, that the older generation will probably be hoping to be feathering their super fund through the next recession. and then they'll tap out and hopefully get a little payout from the people that are their current managers to go, hey, I'll sell you my my interest in the partnership. Now that times are good again, I'm going to tap out, and you can wait 8 or 10 years until the next recession for your payday. So look, it's competitive. It's competitive, and companies have less and less money. I mean, in 3 months, there's going to be heaps of liquidations, but they're not going to have anything. I mean, if all they have is JobKeeper, there's not going to be assets. A lot of liquidators, you can get paid from that preference payment I mentioned before. Usually the ATO gets paid in the 6 months before liquidation, and it's pretty easy to get the money back out. I've got 600 grand of ATO preferences at the moment, but there's not going to be any ATO payments for 6 months. So there's going to be no preferences. There's going to be no assets. There won't be a business to sell. So it's really just the 5.5 grand that you get up front, if you can get that.
Okay.
Yeah.
So Jarvis, what makes a good liquidator? So, just say you're at capacity and we have to look for somebody else. How would you choose or know who's a good liquidator, and is there such a thing?
I think that's where the relationship comes in to play beforehand. I mean, there's some bigger name firms, and I think, you'll go and see them, or you send your client to them, and they'll give the traditional, I do liquidation, I do administration, I do bankruptcy. They won't talk about that informal stuff about, hey, what can you do to actually not have to use me, because we don't get paid for that really. But that's where I guess I play a bit of a long game. You've got to choose whether you're in it for the short game to get the jobs, or whether you're in the long game for the relationships and sort of a reputation and to be trusted, so that people do feel confident and comfortable sending their client to you. So I think, just having that relationship and knowing what the person is important. So there's a Brisbane liquidator, highly litigious, like sues anyone. I know a couple of people have referred clients to him voluntarily. He's turned around and sued them. And one of his staff at a social thing said, oh, well, our model is just to go to lawyers. We get court liquidations. We sue everyone. That's what we do. That's our business model. Now, some people say that's a good liquidator, like treating directors like they've all done the wrong thing and suing them. I don't personally think that's a bit litigious. And at the end of the day, I don't think they're necessarily going to get more money back for creditors, because they'll spend hundreds of thousands on legal fees and liquidators' fees to squeeze money out of people. You get people who say on one end of the spectrum that they're a friendly liquidator, and I think that's fraught with danger as well, because one, if they're not telling you what you need to know up front and then they get appointed, you can't reverse that and go, oh, actually, they seemed like a good guy, and then they completely changed once I handed over control. That certainly happens. So when I talk to people, I say, look, I'm a no surprises kind of liquidator. I'm a straight shooter, down the middle. If there are issues, I've got to look at them. That's my job. I'm telling you about it now so that you can make the right decision and go into it with your eyes open and seek legal advice. And I refer people to other lawyers to get advice, so that, fine, if they come back to me, then they're informed. So, I mean, I guess, the benefit for liquidators is having uninformed directors. So they come into it and they've got assets and there's claims and it's all a mess. And lo and behold, the liquidator's got, a lot of work to do. But these days, people are more savvy. They're cleaning up the company books. They're fixing up the issues before they appoint someone. So, look, I'll always be available. But if not, there's a few people around that. I mean, you're in Brisbane, aren't you? So.
No, I'm in Sydney. But can I ask?
I've got a team in Sydney as well, and I'm trying to make them a liquidator. Yeah. So I'm encouraging them to become liquidators. So there'll be someone. I can sort you out.
You said before that you get paid your 5.5 grand. Do you get paid 5.5? Is that it?
Sometimes, yeah. So there's tradition, you write off. Well, you try to write off, as least as possible, but you try to, maybe 5 to 10 you write off to do it, and hopefully, less than 20 or 30 you write off. I mean, court liquidations, there was a report a few years ago, liquidators do about 50 mil of unpaid work and have 27 mil of unpaid expenses, so out of pockets for court liquidations or for liquidation work. That was a few years ago. So our charge out rates effectively are probably higher to build in, what is often a 40% write-off as industry standard. So you try to get that write-off down a little bit. But if a company's got nothing, you either I mean, the online benchmark's about 5.5. A few liquidators, because they don't have any work, they're dropping it to sort of 4s, and I've even heard of 3s, which...
Why would you take on that job?
Exactly. But what? It's because your team's sitting there with nothing to do.
Okay.
I guess you know that in September...
recovery rather than, and utilisation. Okay.
Yeah, I mean, I guess, do $3,000 of work if you're not going to be doing any work. So, I mean, come September, in theory, it's going to be busy times for the next 3 or 4 years for liquidators. So you just have to cross the bridge until we get there. And it's a bit weird. It's a recession and liquidators aren't busy. So it's strange times.
Yet.
Do you think the director's ID will make any difference to the phoenixing activity?
I think it's pockets of activity. Like I've seen it in Western Sydney. Melbourne had some real big operators. It is difficult, because we'll have, someone will have to get, well, all we'll do is we'll get the 5 listings under that person's name and try and work out, well, which ones are their companies, because I think it'll help.
I don't.
Pardon? You don't?
And I'll tell you why, because I've been working on this with the ATO.
Yeah.
So the problem is with phoenixing is that what they do is they close it down and they get cousin to open up, right? Director IDs are not joining people together.
Yeah.
So they actually don't know husband, wife, cousin, brother, or any of those relationships. And I'm like, but isn't that Phoenixing 101?
Yeah, well, that's right. So, I mean, look, ASIC can automatically ban someone where they've got 2 companies in liquidation in 7 years of each other. They do and they don't. I mean, I think it might help. I just think
maybe
early ATO intervention is going to minimize the loss, and then just the people that facilitate it. I mean, the ATO and the ASIC would know who the facilitators are. Their names would turn up as the referrers of the liquidation or as the advisor on the job. And if they're not, well, then the liquidator needs to be punted because they're not being the gatekeeper that they need to be. Yeah, so maybe.
Best session ever, Heather.
Yes. Thank you so much, Jarvis. You've said you've explained everything so well. I feel like you should give us an exam at the end of this.
It's okay. I'm sure there'll be some real life exams, so we'll see how you do then.
Unfortunately, but I hope and as well as a lot of people are contacting me, telling me they're watching it online as well because they've got children screaming in the background. So I hope everyone got a lot out of the session. I know I did get a lot out of the session and really appreciate you spending the time with us, explaining it, really unpacking it for us so we can assist our clients in turn. I've posted Jarvis's details in the sidebar, so please do contact him sooner rather than later, and make sure that you know how to get in contact with him if you do need assistance. Really, thank you so much, Jarvis. Really appreciate it.
Yeah, no, it's a pleasure. So just like I said, treat me like an extension of your firm. Pick up the phone. Happy to answer any queries. Do it on an anonymous basis. You don't have to tell me who the client is. Happy to, and even if it's just a thought bubble, you're trying to work something out, happy to help. Do templates up to help with those conversations. So hopefully help a few more businesses stay alive.
Thank you so much, and thank you everyone for jumping on, asking your questions, and joining in. And I'll, if there's nothing else, I'll end the session for everyone. Really appreciate it, Jarvis.
Thank you. Thanks for the opportunity, everyone. Thanks for listening.
Thank you so much.
My pleasure.
Bye. Have a good evening, everyone.
Bye.
Thank you so much. Bye.